There we go. Perfect. Okay. So just a couple guidelines as we get started. So we know that we have many international students that have joined us today. And we just want to mention within ISSS that the spring semester guidance from SEVP has not been released yet. So we will not really be discussing that in today's session. You will want to go to the FAQs on our website if you have any questions about spring guidance, and we will be posting information there as quickly as we can once that's available. I believe Anna, Christine, or Tyler are going to put that in the chat for us, that website. Also, questions can be asked in the Q&A function on the bottom of the screen, as well as the chat function. ISSS team members, Anna, Tyler, and Christine, will answer questions during the presentation that are relevant to ISSS. Other questions that are relevant for Bob and Debra will be saved until the end of the presentation for the three of us to answer. And finally, this webinar will be recorded for anyone unable to attend, and we will send it to international students and scholars after the presentation. So with that, I'd like to welcome Bob and Debra.
Okay, thank you so much, Amy. And obviously, this presentation on new developments in immigration is quite timely, given what has transpired and what may transpire in the future. So first and foremost, we really want to express, Debra and I really want to express our appreciation to ISSS for allowing us to meet with you, for making us feel that we're full partners with the immigration program at the university. We've been working with CU Denver for, I think, the better part of a decade. And it's been a marvelous, fulfilling, and quite productive partnership. So again, thank you, and really all credit is to ISSS for really setting this up and expanding the program offerings to you. What Debra and I want to do, and next slide, please, is essentially this presentation is broken into three segments. Segment number one is let's take a look at what has transpired, kind of at the 30,000-foot level in immigration over the past several months. And obviously, immigration has moved to the front burner in terms of both a wedge issue, in terms of an issue attracting widespread national attention, to say nothing of impacting your own personal and professional futures. The second element of our presentation is we're going to take a bit of a deeper dive into a couple of the major proposals that are currently on the table that profoundly affect you, largely in terms of J and F terms of eligibility, in terms of revisions to the H-1B program. These are core immigration matters that affect you very deeply. The third and final segment of our presentation is speculative. What might we expect from the Biden administration? We know kind of what the president-elect seeks to accomplish. He's been actually more clear than pretty much any predecessor in sketching out some objectives he hopes to accomplish in the immigration field. Whether he can do it and under what timeline is going to be a matter that we'll just have to wait and see. But at least let's start with an understanding of where he would like to come out. Next slide, please. If you take a look at what's gone on over the past years, there have been just an immense torrent of new immigration provisions. The Nonpartisan Migration Policy Institute has calculated that over the past years, there have been roughly 400 changes to our immigration laws and regulations and policies. That's an immense, immense amount of changes. So what we want to do is kind of walk through a little bit on how to approach it. Next slide, please. So of these 400 changes, it's important, and this gets into the realm of American civics, to understand how these changes are structured. Because once you understand how they're structured, then you can start to approach the means by which they could be changed under a Biden administration and what the timeline is for change. So let me run through real quickly the different categories within the US legal system for cataloging basically law and policy changes. And then at the end, we're going to be returning to these concepts as we try to figure out what to expect under a Biden administration. So at the top of the pyramid is the Constitution of the United States, and amendments that would solidify within US law various provisions in immigration. We haven't seen any constitutional amendments. Secondly, below the Constitution are statutes, that is, laws passed by the Congress, signed into law by the president. So those, again, long ramp time for a long and complex time to develop, to pass, to implement. Below statutes are regulations, which essentially are the internal documents or internal policies used by the various federal agencies in implementing, in our case, immigration laws. And there's a certain procedure to develop regulations. Below that is executive orders, that is, unilateral pronouncements by the president that impact immigration law and policy. So executive orders have to be done in accord with the Constitution, with statutes, but the president still has considerable latitude of action in enacting new policies. But conversely, whereas you can have an executive order today, it can also be undone by a subsequent executive order tomorrow. And then this whole policy, there's also the checkpoint of the courts. That is, the judicial branch has the right, has the obligation to weigh in to make sure that this whole process is working in accordance with US law, that there are no violations of controlling doctrine, controlling laws to various provisions. So, and what we have seen is unquestionably a very active attitude by the courts in looking at our immigration laws and what they hold. So let's now turn some attention to what's going on. Debra, next slide, please.
Sure. So in looking at the taxonomy that Bob has outlined, we can take a look at what has happened really over the last 4 years. So obviously, as we know, there hasn't been any amendments to the Constitution for quite some time. But the bigger question is, has there been statutory reform? Have we seen Congress pass any type of legislation for immigration? And we can say no, there has not been any changes to the statutes that are governing immigration law as we know it. But what we have seen under the administration is a lot of regulatory changes, and I would say quite a bit really within the last few months has kept us extremely busy. So for regulations, these are rules that are promulgated under the APA that really define how the agency is going to be interpreting the regulations. So what they do is pass essentially new laws, new rules that are going to define how and interpret the statute. So what have we seen happen? Well, there's proposed rules to change the J1 and F1 that are going to be coming up shortly later in the talk. We've seen constrictions for the entire H-1B program, both in redefining what constitutes specialty occupations and revising the wage structure that we've known and used for the last 20 years. There's been a new implementation on public charge, which has always existed in the law, but never to the extent that we see today, where they've even devised new forms as, in a sense, doing a wealth test of those applying to become green card holders in the United States. And we've also seen earlier a move on targeting foreign students with online courses, right? Even in the midst of a pandemic, there was vast confusion as to whether you would still be allowed to obtain your F1 and attend school if it went fully remote. And all of these were done through regulatory proposals through the Federal Register. Bob, do you want to talk a bit about executive order?
Yeah, so next slide.
Been used by the administration?
Yeah, so now look,
Next
we
slide,
have a, yeah, okay, this is the stuff that disproportionately makes the front pages of the paper. And in a way, it stems from an avowed commitment by President Trump to reconstitute the immigration situation in the United States, the laws, the policies of immigration. And what we've had over the past 4 years is literally a slew of executive orders. So these are things that are promulgated by the president and has impact in immigration. And again, all of in order to be sustained, the president's executive order cannot run afoul of statutes of the Constitution. So there are boundaries, but one of the things about immigration is that it does recognize that there are significant foreign policy implications in immigration, and as a consequence, the president, as the head of the executive, has some fairly significant latitude to create immigration law and policy on his or her own accord. So what have we seen? One thing we've seen, and Debra's going to get back to this, is travel bans. There have been just a large number of travel bans, which either single out certain countries for kind of national security type considerations as not being suitable for or amenable to for visa issuance and travel. It's gotten expanded with the COVID virus for public health reasons. There have also been a number of constrictions. There have been constrictions also emanating out of the growing unemployment rate, leading to a constriction in visa issuance. So that's been a major area of presidential activity, which, by the way, has some major implications on your ability to go home and see family, on your ability to take a vacation back into your home country. Certainly the DACA, the Deferred Action for Childhood Arrivals, the program that tries to give legal protection to childhood arrivals who came to the United States without authorization, but literally they were brought by their own parents. So this has been an incredibly contentious issue, which optimally the Congress would pass a law to address once and for all. But in the absence of congressional action, the president has kind of stepped in. TPS, one of the things we've seen in the Trump administration has been a curtailment of humanitarian concerns in immigration law and policy. So TPS, or temporary protected status, is an initiative to provide foreign nationals in the United States in which their country is embroiled in civil disruption, in which their essential welfare, their essential safety would be jeopardized if they went home, temporary protection. And the president is somewhat systematically preening down the number of countries qualifying for TPS. There's been just a terrible mess on the southern border as to who's allowed to come into the United States to present asylum claims, the family separation, the grounds for asylum. Does that directly impact you? It may on several individuals on this call, but probably most not, but just be aware. There is a developing enforcement action, which Debra's going to get back to, which is somewhat emblematic of the attitude of the U.S. government toward foreign students or international students, which is something called Operation Optical Illusion, which is looking at F1 students holding optional practical training and digging very deeply if they are fully upholding their employment obligations under OPT. Debra's going to get back to that, but it's obviously something of major concern to the international student community. Next slide, please. In addition, what do we have? Increase in premium processing fees. So to get, we have terribly elongated processing times for many immigration petitions. It's almost a matter of widespread acceptance. Almost everyone pays premium processing to force the immigration authorities, U.S. Citizenship and Immigration Services, to process petitions in an acceptable time frame, 15 days. That's been raised to $2,500. It's going to put a dent in your pocketbook if you're required to pay premium processing fees. For Chinese scholars, for Chinese and students, there's a new policy to disallow Chinese nationals to come to the United States if in their background they have a connection with military fusion strategy. That is, if the nature of their work could connect, if the dots would connect to the kind of national security apparatus in China. There have been revisions on how you can change from, let's say you come in as a visitor and going into student status. You need to maintain an underlying non-immigrant status. It used to be that once you filed your change of status application, that would be it. Now you have to go through an additional step of maintaining and extending your non-immigrant status. Again, it's a destabilizing element requiring USCIS to adjudicate and make a decision. One of the really destabilizing actions, policies, which I do believe will be reversed in short order under Biden, is something called a rescission of the deference policy. And what that said is that if immigration made a decision in an immigration case, absent significant change circumstances and absent fraud, extensions would be granted. Now, what happens is you can be approved for, let's say, H-1B status, but to get an extension, you have to go through the entire rigmarole all over again, make your case A to Z, and the Immigration Service, USCIS, is not bound or even unduly influenced by a previous approval. They re-adjudicate, and with that goes the possibility of denial. You also now have the requirement of appearing personally to get your green card and the adjustment of status. Is that a big thing? Arguably not. But again, it's just another intrusion into and another step in the process to get permanent residence. And then there's another thing, and again, Debra's going to be talking about this, which is there's when many of you will be going from F1 or J1 into H1B status, quite possibly with private for-profit industrial or private sector concerns, meaning you're going to go into a potentially a lottery-based system because there's not enough H-1B visa numbers to satisfy demand. And the criteria now to select the overage is going to be largely based on salary figures, salary levels, meaning that if you're if you're just coming out of college, if this is an entry-level job, very possibly you're going to be at a major disadvantage in terms of lottery selection. So this is a little bit like a Hieronymus Bosch painting, the Garden of Earthly Delights. It's an unfolding horror story, but still, this is the environment in which we are existing today. Having said that, I do want you to know that you have, you're superbly gifted. You have marvelous skill sets which have been developed at the university. And all things considered, do we still think you have promising prospects for immigration? Yes, but it's not a walk in the park. It is a delicate dance you have to do now. And these last two slides are intended to kind of present some of the overall both policies and attitudes, frankly, that are in existence now. So, Debra, what's going on? Next slide, please. Debra, are you silenced? Okay, I'm going to take things over. I believe Debra's had some instability.
Well, I love your analogy to a walk in the park. I think it's like walking in the park and having a concert. Oh, can you hear me?
Keep going. Yeah, let's give it a shot, Debra.
Oh. Can you hear me now?
Yes, I believe. Okay.
Okay, hi, I apologize, everyone. So this really wanted to give you of what we've seen happen under the Trump administration. And what we've really seen is amazing.
Okay. Debra, let me take
to
this.
the cutoff of immigration. The first thing the administration has looked to do is really can they eliminate and curtail family immigration. And so with this, we've seen an incredible amount of long processing times. Mm-hmm.
Keep going. Okay. I'm sorry. Let me take this slide and let's try to get back the next slide. So,
right. And benefits, as Bob has discussed regarding TPS, about the DV lottery, their goal has been increasing enforcement.
Okay. Okay. I'm sorry. I'm going to step in. As say, Debra's been having some instability in her internet, but what the slide does is to identify 4 basic changes in our immigration laws and policies. Number 1, cutting back on chain migration. That is the ability of family to serve as the basis for immigration. That's been front and center to the Trump administration. Number 2, ending humanitarian benefits, cutting down on asylum, cutting down on just a range of benefits that are premised on basic decency and equities. Number 3, there's been a huge spike in enforcement. that is coming into the country without authorization has been traditionally, that subjects you to eviction through the deportation process. But now in addition, it's become a criminal act. And in addition, there's been a great deal of emphasis in keeping basically foreign nationals in their lanes, in the sense that violations of status become subject to greatly enhanced enforcement action. And again, we're going to see this particularly in a section which I'll be covering on revisions to the J and the F visa categories, in which immigration is imposing substantially new restrictions. And if you violate, again, you become subject to basically loss of status. And then lastly, there's been a sustained effort to decrease legal immigration, to make it harder to get visa status, particularly based on, in our situation, on employment. And we're going to see this in terms of the revisions to the H-1B. Okay, next slide. And Debra, if you can hear, let's give it a shot with your audio. Okay, then I'm going to keep going, but I just want to let you know that Debra has authored this set of slides.
Hi, everyone. I'm testing this out. Hopefully you can hear me.
Yes, we can. I guess no, we can't. Okay. Here's the first thing we want to cover. Over the past years,
So
there's been a Debra, I think that you really have such instability that let me drive this forward, at least for the time being. The first area we've seen some major restrictions that affect you is a series of travel bans. That is, travel bans that significantly restrict the ability of foreign nationals to come into the United States. And in large measure, not total measure, but in large measure, the Supreme Court has upheld the ability of the president to restrict entry to the United States, admission to the United States. There is a cutoff point beyond which the president cannot go if it is based on religion, if it basically is the Muslim ban, but it's based on if restrictions are based on religious grounds. But if not, the president has pretty much a clean slate to enact restrictions. So pre-COVID, so pre-March of 2020, there was the first set of countries that faced, largely for political reasons and national security reasons, that faced restrictions. And they're listed out here. Then, next slide. Then, post-COVID, you've had another series of restrictions, which are in large measure based on public health considerations. So again, China, Brazil, Iran, UK, Ireland, the Schengen countries, so that's basically the European Union, have all been put on restriction as a matter of public health considerations. Then first in April and then in June, the president announced significant restrictions in the issuance of H-1B issuance and permanent residence to foreign nationals residing abroad. That was based largely on a concern with the growing unemployment rates. And so what the president did is said, we're not going to be issuing, or he created major restrictions to the issuance of H-1B visas, L-1 visas, and permanent residence to foreign nationals residing abroad. That's been whittled down somewhat, but still there were significant restrictions as to who could come. If someone was in the United States, then they were exempt from those presidential bans. In parallel to this, the US Embassy, largely in reaction to the COVID virus, has, many US consulates have restricted hours or restricted the scope of services, only providing services to US citizens. So again, this whole notion of ease of international travel has really gotten turned on its head. And I would think that probably the general guidance put out by ISSS, and is particularly as we're approaching the holiday season, is one of either not traveling or traveling only with a great deal of caution, and also with kind of a backup plan in case you get caught abroad. How do you handle unexpected and prolonged absences from the United States? If there's nothing else, and I gotta say, this is a prediction, you can pillory me if I'm incorrect, it won't be the first time, but this is probably something that the Biden administration is going to address within the first 5 days of its administration. They've gone on record pretty ardently saying that they want to see the United States re-engaging with the global community. They do not favor international travel restrictions. They want to see a more robust international travel. I think it will be guided by COVID sensitivities, so it'll be public health, but we're not going to see this injection of kind of blanket restrictions to H-1B issuance or green card issuance. Okay, and next slide, please. Travel bans in terms of this slide basically deals with kind of, given the restrictions, how do you best present your case? So student visas have been basically reinstated as of July, particularly for H-1B, but actually for many other travels. You want to be able to show that travel to the United States is not simply for reasons of personal pleasure, but have a major impact in terms of the betterment of an employer or betterment of the country. You need to have a designated reason to travel to the United States. It's simply a practice element. One of the things, and I'm not saying this as a self-serving matter, but for international travel, you probably want to get, if you decide to travel, you probably want to get some legal advice in terms of what's the considerations, what's the situation in your home country, and so on. You cannot enter this blindly. Okay, next slide, please. Okay, here's a major new initiative coming out of the administration, and this has been presented. Remember the chart or the slide on how new laws and policies get represented in the United States. This is something that is being implemented as a regulation. So this is not something that the Biden administration can override with the stroke of a pen. It's going to have assuming that the restrictions on F1 and J1 visa classification is implemented, it will require a more lengthy and considered approach to getting rid of it. But over the past years, we've seen kind of a somewhat of a steady attack on student and scholar eligibility. Last summer, the immigration authorities said that if a campus goes to remote learning, an international student could no longer come to the United States. That was rescinded in the face of just immense and widespread opposition within the academic and broader community. But we're seeing major visa delays. We're seeing some suspensions in the exchange visitor program, and something which ISSS, Amy Bello knows all too well, more and more pressure being put on SEVIS to make sure that it is fully discharging its obligations as enforcement, making sure that everyone is in place. But then what happened was in October, it was basically there was a proposed. It was a notice of proposed rulemaking, or was it September? I can't remember when it was. But anyway, recently the Immigration and Customs Enforcement floated a new proposed rule. And here's what it does. For years, in fact, dating back to 1980, when an international student comes in under F1 and F1V student visa, what the US government did is it said, look, as long as you continue to be a student in good standing, we're going to let you continue in your student program. And therefore, we will admit you not for a specific date, but rather we're going to admit you for duration of status. And as long as you're maintaining the status of a student, you're going to be fine by us. You're maintaining F1 student status. Then particularly in the aftermath of 9/11, a lot of the kind of monitoring functions was vested in a new program called SEVIS, which is administered by ISSS, which is kind of a web-based technology that monitors and makes sure that basically tracks student progress and tracks J1 progress. So also, J1 scholars would be admitted for duration of status, although they have a maximum limit. But again, as long as they're basically doing what they're supposed to do, they're fine. They don't have to go and apply for extensions. They don't have to go to immigration. It's really ISSS, which is monitoring compliance. And then if someone, a student or a scholar, violates status, again, that is not good, but at least they don't subject themselves to something called unlawful presence, which is a determination that if you violate your status for 180 days or more, you're going to be barred for 3 years from coming to the United States. Or if you violate your status for over 360 days, you're going to be barred for 10 years. Basically, in student and scholar life, F and J, the belief was, look, this is complex stuff. And you've got, highly accomplished individuals. And if they do violate their status, unless it is quite egregious, we're not going to start counting these 3 and 10-year bars, we're simply going to, basically, they're going to have to, leave or get back in status. And Amy Bello and your colleagues at ISSS had a lot of discretion to figure out, was someone's violation of status justifiable? Should they be reinstated? Are there equitable grounds to recognize what's happened? In a sense, this new proposal, this new proposed rule, which is coming out for F1 and J1s, upends this whole system. What it does is it says, we're not going to, from immigration, we're not going to basically entrust to ISSS the monitoring, the enforcement function of F and Js. Rather, we, the immigration authorities, are going, and the State Department authorities for the J1, we're going to interject ourselves, and we're going to make determinations if someone is truly a full-time student doing what they're supposed to be doing, making satisfactory progress toward degree completion. So first of all, as opposed to coming in under duration of status, DS, this new rule, which by the way has not been implemented yet, says we're going to have a maximum of 4 years you're allowed to come into the United States. Once you hit the 4-year mark, you're going to have to apply for an extension, meaning it goes over ISSS. They have to agree, but the ultimate determining authority is going to be the immigration and customs enforcement. Immigration is going to make the decision, is the student making adequate progress? Is this a good degree program? Should they be allowed to continue in their program? All of these things. It represents really a major new change. In addition, it used to be, or it is right now, that once a student completes his or her student program, they get 60 days to pack their bags, to say goodbye, to make a final trip to the Statue of Liberty, or to take time. They have 60 days to leave the United States. The grace period now has gone down to 30 days. The whole idea, though, and then in addition, if a student or J1 scholar resides beyond the duration of time they're allowed, which immigration has provided to them, they start accruing unlawful presence. They start to subject themselves to the possibility of being barred for 3 and 10 years. It's literally a much more enforcement-oriented program we're seeing right now. And what's also really bothersome is that ISSS understands the educational and professional goals of students and scholars. And they understand what's required to basically fulfill the academic mission of the University of Colorado, Denver. And to have immigration interpose itself and make those judgments is extraordinarily concerning. The one good thing is the cap gap, the ability of an F1 student to maintain status as they're waiting for the outcome of a new H-1B case has been extended not to October, but to April 1. That's kind of a bone that they were tossed. But the status of this is the F1 and J1 rule has just elicited a great deal of opposition. Literally, I mean, I've heard reports anywhere from 20 to 30,000 comments have been received. The CU Denver has filed a very compelling, a very well-crafted oppositional statement to this rule. We have no idea if this will be implemented. my own belief, and again, get the pillory out against me, is that freed from any type of kind of external judgment by the electorate, the Trump administration will implement this rule, meaning that Biden will come in with a rule in place, a regulation in place that will require addressing, but it cannot be dispensed with by the stroke of a pen. Next slide, please. So in terms of employment, what's the story? So and again, employment within the student and scholar context has, it's not one size fits all. For on-campus employment, there's an automatic extension of up to 180 days. So, if you have on-campus employment and you're applying for an extension beyond 4 years, you still get up to 180 days of extended employment. But if you're in CPT, if you're taking internships, you have to apply for employment authorization and it has to be approved. So this is, again, it's this interjection of immigration. And same with OPT. Not only you have to apply for an extension of status and you have to apply for your employment card, both together. Okay, next and last slide on F1J1. I guess there are two. In terms of Operation Optical Illusion, basically what it says is it reflects a government belief that F1 students are not really working in as they're required to do under OPT. And so they're sending out investigators to basically look at, is someone working in the job they described, in the position they described? If not, they're finding violations. Next, please. Okay, last thing I want to say for J1s, if you hit, they're also subject to this 4-year mark, but they get a 240-day automatic extension if they need additional time. But again, immigration will be making the ultimate decision whether a program should be extended, whether it's to complete a doctoral program or to complete a postdoc or program in graduate medical education. All of that becomes subject to immigration determinations. Okay, next slide, and I'm hoping that Debra's audio is back on track. Debra?
Me too. Thank you so much, Bob. I appreciate you jumping in for me. Let's give him a little kudos. He's fantastic. So in addition to what you just saw regarding the proposed student changes, there's also proposed changes to the H-1B program, which, as many as you know, is the most common used work authorization visa in the United States for those working in professional occupations. And we saw happen 2 proposed new rules impacting the H-1Bs, which came out on my birthday, so a lovely present from the government. And the first thing that it did, and which actually began immediately upon publication, were revisions to the prevailing wage rule. And what we saw was a dramatic increase in the wages that are used in H-1B. As many of you may know, the Department of Labor publishes wage scales based on occupation, and there's 4 tiers. And most individuals coming out of college are going to qualify usually for a level 1, which is an entry-level position. Makes a lot of sense. And historically, the Department of Labor has set that wage scale at what they call the 17th percent, meaning in looking at all other employers in that occupation, you have to pay at least the 17th percentile. And what they've done is taken that 17th percentile and now say, no, we think you need to pay at the 45th percentile. So as you can see, that's a huge jump in what your expectation of employers need to pay. Does that mean all of you are like, great, now I'm going to get a huge raise for any new job I get? I think the contrary is going to happen. I think it's going to make it much more difficult for employers to sponsor H-1B workers, because using these OAS wages are going to put them out of line with what they're paying other employees who are US citizens in the same occupation. So that's a huge problem because it's basically trying to prevent employers from using the H-1B program. They're making it much more difficult. With the wage scales, we have also discovered that many of the occupations that normally had wage rates have disappeared. Meaning the Department of Labor had determined it no longer had enough data to designate wages. And so there's a default wage that's listed, which is usually $100 an hour, which also sounds fantastic, but again, unrealistic that most employers are going to offer that for positions. And so what do we do? This is something we are facing today. So any new H-1B petition, including extensions, change of employer, or amended filings, if an LCA is required with your H-1B, this law you're subject to right now. And so fortunately, the one bright spot is that they did not change the rules that allow the use of alternative surveys. And so there are quite a few surveys available put out by industry where they did their own evaluation. And if an appropriate survey is found for your occupation and experience and education requirements, an employer may use the survey instead of the published DOL wages. And that may be a carve out to allow H-1Bs to proceed. There are also 3 current lawsuits. Of course, universities and private employers immediately went to court to challenge this rule because it's a huge change of what we've seen. And there was supposed to be a hearing on the 13th. My understanding is the judge noted that they will provide a written decision, and we're waiting anxiously, constantly checking feeds to see when that comes out, hoping that this gets enjoined. But this is a big change, and it is, again, when the Biden administration takes over, we do believe this will be looked at again. We don't know if it will revert back to the original wages or if they'll come up with their own system, but it'd be highly unlikely that this will be kept in the system that it is today. Next slide. So in talking about what also came out at the same time was a proposed regulatory change to the H-1B rules. This did have a notice and comment period, which is ongoing, and it does not actually begin until December 7th. And there were really 5 elements that came into play with these new rules. The first is they amended the definition of a specialty occupation. And what a specialty occupation has historically mean is an individual with a bachelor's degree or higher as the minimum entry for work in that position. And an employer sponsoring an H-1B has always had 4 means under the regulation to prove this. And they have now narrowed the definition of specialty occupation to require a specific degree in order to perform the position. So what you may have seen, for example, is a company looking for someone in engineering. And they may have said, we'll be willing to accept mechanical, industrial, quality engineering, or related engineering field, maybe even electrical engineering or computer science. What they've done now is say, if you're going to offer alternative degrees, you have to prove that each of those degrees are required for the position. And how they've made this a bit more complicated is they've also revised the definition. The regulations used to say a company can prove that it was normal to the occupation. They've revised the word normal to now say always. So you must show that it's always a requirement to have this degree to qualify for the specialty occupation. So this is going to require more documentation for an H-1B position, use of alternative sources, third-party sources to define this. What we also saw, quite often the immigration agency has always turned to the Occupational Outlook Handbook and something called ONET. And as of yesterday, they released a whole new section on ONET that has taken away much of the tasks and the definitions that had always been found in occupations. So again, this program is being targeted tremendously before the exit of this administration. A few other changes that came out. They also, this deference policy that Bob had mentioned that has been very sad to see applied has now been codified. So where before it was done by policy memo, kind of falling under that executive action, they're now codifying it, meaning it's part of the regulations, meaning it's making it much harder to take away, at least in terms of the H-1B program. Finally, the other two components that have come into play really involve looking at third-party placement. Normally, you're looking at consulting companies where you work for a staffing agency that places you to work, say you're at 3M or working for another business. They're now limiting that to 1 year. They're saying if you're not working directly at your employer, we're going to limit it to 1 year. They're redefining what constitutes an employer, meaning an employer is, they've taken out the word consultant as qualified and saying you only qualify if you provide contracts, full employment offer letters. So there's quite a bit more documentation that's now going to be required. Finally, they're also going to increase site visits and enforcements, which means they will send officers to the petitioner and the worksite listed in the LCA and H-1B petition to verify that you're really working there and engaged in the same job duties as listed in the H-1B petition. So a lot of changes coming forward in the H-1B program, but I'll also mention the H-1B lottery, because for many of you who will be graduating soon, this is where you'll be going if you're entering into the private wage market. What happened is, as we've explained, there's a limited number of visas. There are 65,000 for the country, plus an additional 20,000 for those with U.S. master's degree. That still exists. Nothing has changed in terms of the numbers or the U.S. master's program. But they've suggested in another proposed rule that in how they run the lottery will no longer be random. They are now going to look at the wage level scales used. So as we discussed, there are 4 tiers, 1 through 4 levels, and they're going to give those who are paid at the highest wage, the level 4, have a better chance of getting into the lottery than those paid at level 1. And so we as practitioners scratch our heads because last year when we filed to enter the lottery, there was nothing in the lottery program. You didn't have to designate a wage. You didn't even have to designate an occupation. And so how are they going to determine what's the wage and what's the wage scale? So this is not reflected in the proposed rule, but they're going to also have to change the lottery program. Either they're going to require to file a full H-1B petition or file an LCA or make you already have to list, so something's going to change, and we're a little nervous on what those will be. They've also found our loophole of using salary surveys that we discussed that many employees are using right now with the prevailing wage, and have stated in the proposed rule that if you use a salary survey, they will automatically treat that as a level 1 wage, even if it reflects experience. So those are the changes we see coming. The harder part is determine the timing. The lottery, as many of you know, last year the application process was in March. April 1st is the last date of filing for the government's fiscal year for an October 1st start date. With the change of administration coming in January, will there be time to reevaluate the H-1B program and implement the lottery? We don't know. So it will be probably a work in progress as to how we'll do this going forward. Next slide. And so kind of just to summarize, before even these proposed rules came out, what had we seen in the H-1B program? Similar to other types of petitions, you know, there's an overarching policy of no. They've really created a high level burden on petitions. And as we work very closely with the UCD on their own petitions, and Amy can tell you how much additional documentation and how careful the university is in their case preparations. It's really become a much more complex filing. But we still want to tell you that we still have an incredibly high success rate. While the denial rate has tripled, the RFE rate, I don't even know what percentage, but it went from maybe a handful to like half the cases when in the lottery will get RFEs. It's gone up, but fortunately we've still been very successful in getting them. So don't be deterred because the rates of denial have increased or there's additional RFEs. Bona fide job opportunities and well-defined petitions are still approvable. Just be aware that the cost now has gone up premium processing fees. So it's making the cost of an H-1B get quite expensive as well, which could have a deterrent effect on employers willing to sponsor foreign nationals for that very reason. So those are things to just keep in mind as you move forward in the job market. I think this last one is mine too. I'll just briefly mention this. Any of you who will be filing for a change of status petition. So this will also come into play for extending your F1 status. There are questions asked regarding use of public benefits. Essentially, if you've ever received cash assistance or government assistance from the United States government, you have to disclose this. And this will be an evaluating factor as they determine whether to grant the benefit you're applying for. So not only does this apply to non-immigrants in the US, but it also applies to those seeking adjustment of status to become green card holders. There's a new form that was created for those filing adjustment in the US called a 944. It's an extensive form that is requesting information regarding your work history, regarding your financials, both your assets and your liabilities. It's asking for your tax return. It's asking for proof that you have health insurance. It's asking for that, the same thing of your family members. Who are all your dependents? Has anyone in the family ever accepted public benefits? And if so, what? So it's essentially, it's an evaluation. I call it a wealth test, right? How old are you? Are you going to be, they'll do a balancing test at the end of the day to see if the equities waive in the fact where they don't believe there'll be a public charge, or are they weighted towards heavily that you may need to have assistance from the state. I believe and I agree with Bob completely. This is something that I think the Biden administration is going to reverse. It's an arduous, detailed process. And one that, you know, if you're already attending school and employed and have a job, it may not impact you as much, but it definitely has in the family immigration. People who want to sponsor their parents to come over, your parents may be retired, they may not have insurance, they may not be working. I mean, the cost of doing so is going to be much more difficult. So those are things to keep in mind and continue to monitor. And then, oh, me too, good. DACA, I'll just mention it briefly because Bob has already discussed this. What I'll say is the good news is that Biden at least has come out very positive in wanting to make sure that DACA is preserved. He's even brought up bringing back DAPA, which was for basically the parents of US citizen children who don't have status here. Bringing you back, it was first introduced by executive order by President Obama, rescinded by Trump. Supreme Court said, no, your rescission was incorrect, put back into the Department of Homeland Security, which then tried to prevent any new applicants from applying, went to the court who said, Wolf, you're actually not even appointed correctly. You don't have the authority to make this decision, and it's really in limbo. So we do believe in the first 100 days there will be action on DACA, and this will be brought back. Next slide.
Okay. We want to take a look. Okay, and then the last thing we just want to highlight is that beyond the written word, beyond the pronouncements and the regulations, so much of your immigration experience depends on a culture within the immigration agencies. Is it a culture of no? Is it a culture of yes? Is it a dispassionate, fair culture? And what we do feel is over the past years has been a culture of no. So that is something which we're hoping and expecting to see reversed. Next slide, please. We're in kind of the home stretch, and we want to run through and then hopefully have a couple minutes for questions on what to expect from the Biden administration. Going back to one of the original slides, you have to figure where things stand. I mean, look, it's no secret. Biden wants to undo a lot of the immigration initiatives promulgated by Trump. That's out in the open. The issue becomes, what can Biden do unilaterally? What requires a more extended, it's called notice and comment period? which is to change regulations. That can be, a matter of months, years to accomplish. And then the ultimate chestnut is there any possibility for enacting a broad new law, comprehensive immigration reform? Let's take a look real quickly at how these stack up. Next slide. So in terms of what Biden could do, so, on starting January 20th, we do think that he's going to inject more humanitarian elements into immigration. That is, he's already announced that he wants to reinstitute a robust refugee program that is recognizing persecution as a basis for coming to the United States, stopping family separation, stopping the wall construction. He's going to have to deal with the southern border. We certainly expect him, at least as an interim matter, to address DACA, the Deferred Action for Childhood Arrivals. Travel bans, I think that's going to be gone real quickly. Immigration enforcement, I think it's going to be much more humane, much less onerous. And Debra also spoke about public charge. Next slide, please. And I believe that is yours, Debra.
Oh, great. So here's what we could see happen from regulatory changes. As Bob went into detail regarding the F1 and J1 program, again, if this does go into effect, he likely will have his own rules to come out, right? To combat what we all believe will be very negative to the academic community, to come back in and help them. I mean, without a doubt, universities are struggling right now with COVID, financially, economically, with students, and having this hardship on foreign students on top of all this is really just detrimental. And hopefully that administration will see that and produce some better, more open and understandable laws that support the introduction of foreign students in the US. Because it directly ties into the H-1B program. As we've hoped you've understood, is that this administration looked at H-1B workers as really taking jobs away from America. And we hope that the administration instead changes the dialogue, that there are rules in place to protect Americans, fees associated with the H-1B, but it hasn't been an abused system, that it actually advances and fills necessary jobs in the US with top talent. So we believe there will be changes again to the H-1B program. And how to do this, they're going to have to establish rules, right? They're going to have to go through the rulemaking process, unless by the time they get to that, the courts have already intervened and have said the rules didn't follow proper procedures and they're already reversed, right? That's the other option. Congressional override, that I think we can go into a little more detail as we talk about comprehensive immigration reform, and if we think that's possible. Fingers crossed, but we'll let Bob talk about that in the next slide.
Okay. Look, what would be most desirable is literally to have a somewhat wholesale revision of our immigration laws. And Biden would like to see this. It certainly captured the national attention, given the razor thin, given the composition of the Congress, it's very frankly, it's kind of doubtful this could be even initiated in the first 2 years, but we'll see. But the major things that he's at least gone on record is advocating would be, number one, creating a long-term legislative fix for childhood arrivals, the Dreamers Act. Number two, raising immigration quotas. Number three, increasing the number of work visas and also creating some new opportunities for employment-based visas, both permanent residents and temporary residents. One of the things in the green card situation is eliminating the per country cap. That is, only 7% of green cards can go to any one country. And because India and China are such large and well-educated countries, you have inordinately long backlogs. trying to address that, but also raising the quota on the number of green cards. And also, I think he's very interested in seeing a restoration of the United States as being a very competitive country for international education. That is, creating new opportunities for international students, international scholars, greater pathways leading from temporary student or scholar visas to permanent residence. He's talked about making new initiatives for PhDs in STEM disciplines to either get green cards or at least to be removed from the H-1B quota, the cap. So all of these would be things, but again, this is going to take a legislative fix. This will be years in the making. Next slide, please. So the big thing is, how long will it take to change the immigration culture? How long will it take to go from a culture of no to a culture of yes? How long will it take to rescind these kind of enforcement-oriented provisions in which have emerged for students and scholars? I can't give you a timeline. My sense is that there will be some significant changes, but for things that are already engrafted in regulations, it's going to take time. It's going to take probably a year, 2 years to get things totally restabilized. Next slide, please. So with that, we have some time for questions, but both in my own right and Debra's right, this has been a wonderful opportunity to speak with you. We look forward to answering your questions and hope to hear from you in the future. Thank you so much. So
Great. Thank you, Bob and Debra. Go ahead, Bob.
I'm just wondering, does someone want to read some questions, or how do you want to go about things?
Yeah. So Tyler, Christine, and Anna have been helping with the Q&A in the chat pretty much throughout. Does one of you want to kind of, moderate some questions for us?
I can do that, Amy. I can read them off.
Thanks, Tyler.
So Bob and Debra, and I'm just going to go through according to the timestamp that we have for when students have asked these. I'm not sure how much time you both still have available, but we'll just try and keep going until you have to leave or what have you. Our first question is the new H-1B lottery policy based on wages here to stay in the Biden era as well? Bob, I think you may have touched on this.
If it's going to be in a regulation, it's going to be in existence when he comes in, and then he would need to go through a somewhat complex, time-consuming process to reverse it. So, so I think it will be reversed, but it won't be overnight. And also the regulation, by the way, just remember, it has not been implemented. We expect it will be, but it has not become law quite yet. So hope springs eternal that the current administration will not finalize the that provision. Debra, anything you want to add, or?
No, I agree. And we haven't seen yet anyone looking towards litigation, but that could also be a basis that prevents that from happening as well, even before the change of administration. So it's something to watch for.
Okay, thank you. So this is sort of related. Is the H-1B lottery process just for the new ones, or does it also apply to those that already have H-1B status and are asking for an extension?
So I can take that. Once you've been counted in the lottery, you remain in the lotteries. You don't have to enter it again. However, if you were an employee of a cap exempt employer and then are changing to a cap subject employer, you would need to enter the lottery to then do that change. But otherwise, once you've been counted in the cap, you're extending or amending your petition, you don't enter it again.
Okay, thank you. The next question says, does the salary-based H-1B visa affect academic or nonprofit H-1B applications? Or does the academic H-1B applications now require an increase in salary for successful approval or application? This person says they were reading some news about certain universities going to court regarding some issues with salary requirement for H-1B applications. I think we've somewhat touched on this, but maybe you could follow up.
The answer very briefly is that all H-1Bs, whether it is students or, in an academic environment or non-academic environment, are subject to the wage requirements. There is kind of a separate wage scale within the academic community, but you still have to revise and be pegged in at a certain percentage level, meaning that the required wage for H-1B purposes will be increased across the board.
Okay, thank you. This next person asks, can my employer with whom I will do CPT in spring 2021, so our spring term, Bob and Debra, is January through mid-May. If I do CPT in spring 2021, can that employer file for my H-1B as of April of 2021? I will be completing my degree program in May of next year. I think it depends.
May of 2022?
Go ahead, sorry.
Actually, Debra should answer it, but just, is it degree completion in May of 2022?
2021.
Okay. Debra?
Yeah, so if it's a bachelor's level degree, you have to have the degree at the time of applying. You'd have to qualify. If it's a master's, there's been some question as to whether if you were everything completed, but for having the diploma issued of applying under the U.S. Masters, and then when you actually file the petition, because you do have a 90-day period to file if you're selected in the lottery, to then show that you had the U.S. Masters, and that was successful. But you could not enter an H-1B lottery without having your bachelor's degree.
Okay, thank you. That's helpful. The next question is, when do we know when the H-1B new wage lawsuit is going to be resolved? If the lawsuit is not resolved and I don't meet the wage requirement, what are the chances of getting an H-1B through a salary survey? If the H-1B is declined and OPT is ended, will my department have to pay the fee? This might be somewhat of a question for our university, but I think you've already answered this, Bob. Like, we're not sure about what's going on with pending litigation.
No, the only thing is that I got to say the indications are somewhat favorable. I mean, the government played so fast and loose with how it was presented, the wage issue, and short-circuiting the ability for the public to meaningfully weigh in, that we think the courts are going to disallow the proposed reg. Again, could I be wrong? Yes, but this is something I'm actually going to be pretty optimistic that the courts are just not going to stand for how fast and loose and really cavalier the Department of Labor has been in its wage rule.
Okay.
And I can say that ISSS went through very carefully and diligently its H-1B workers. And we have already done a wage evaluation, and we already are working with our own channels within the university on surveys the university already has. It already does a very robust actual wage evaluation for many wage scales. And so we are optimistic for anyone who needs an extension within the next month or so until we hear from the courts, that we'll still be able to proceed using surveys as needed. And a lot of this is a case-by-case basis. We're just going to have to see where things fall. Yeah, some of you really are still paid even at the current higher wages, so don't give up.
Tyler, are there any other questions that we can answer right now?
Right, yeah, we can keep going. I didn't know if you wanted to keep going.
Oh, yeah.
Well, we'll end. Okay, great.
Okay. Since the university is cap exempt, does the H-1B new wage requirement and lottery apply to universities as well? Cap exempt institutions.
Well, the university is not, I mean, if the employment is by the university, you're cap exempt. So you
Right.
don't have to worry about the cap. And remember, the cap is, I mean, that has not been created recently. That goes back. So that's kind of here to stay, at least for the foreseeable future. In terms of the salary, as of today, the salary requirement is in effect. So.
Okay. A person asks, what do you think the likelihood of the travel ban being reinstated after December 31st would be? That's kind of a open-ended. I'm not sure if anybody can say, even though the administration is changing.
Let me just take this. I think I actually kind of think that the question is a little bit the reverse. There's a travel ban. What's the likelihood of it being overturned? I think it's quite high.
Okay.
Yeah, and in the interim, the two bans that are in place regarding H-1Bs and immigrant visas do expire 12/31. I would presume the current president will extend those through the end of the presidency. Whether they just let them lapse, that's just personal conjecture. I have no idea, but I would doubt it. But again, it will all change after the new administration.
And their current administration set to end January 21st.
January 20th, but yeah.
Is the Department of Labor wage change already in effect? What if you had filed before the new rule came out?
Yes, it's in effect, and it does not impact any current H-1B holders. If you're in H-1B status, you're fine. If you already filed your H-1B, you're fine. It's only new LCAs going forward. So any new extensions or any new change of employer petitions or new change of status petitions are going to be subject to these new wage scales. If you already have an LCA governing your position, you're fine.
Okay, this one is a collection of questions from Abhimitra. Is asking, what are the possibilities and process for moving from a cap exempt H-1B to a cap subject H-1B? What are the considerations for that move? And would job seekers need to leave the US if the case is picked in the lottery and is on cap exempt H-1B? I'm not sure I fully understand the question, but I think they're just asking what are considerations for moving from a cap exempt to a cap subject H-1B petition?
Let me take the first crack at this. Step number one is obviously get a job. Step number two is to file the H-1B petition basically April 1. That's when the application period opens, and all we know is that that's when immigration will start accepting applications against the quota limited number of visas. Over at some point during the summer, they start making their determinations based on, now traditionally it's been under a pure lottery system. Now it's going to be kind of a hybrid situation of salary plus lottery. Once those, the pool of selected petitions are made, then immigration goes through and adjudicates. Does it meet H-1B requirements? Which, remember, under the proposed H-1B rule, that whole thing is tightened up. So even if you're selected under the lottery, you still have to prove your case. If it is approved, then conceivably the foreign national can start working after October 1, although it's, it could be you get a final adjudication in November, December. The one thing which is hard to answer in the abstract is the foreign national has to have some basis under which to stay in the United States. But we're assuming, or I'm assuming, that the H-1B filing is made when the foreign national, when the student is still in status, so that they are able to remain in the United States until a final decision is made. Debra, am I missing any steps or
Well,
misstating?
it seems that this question is pretty nuanced. I think that it would require following up with Immigration Counsel regardless. Abimitra, if you wanted to follow up with our office, we could try and connect you with immigration attorney references. But I'll keep going. In the case where a student's graduate degree relates to the job he or she is applying to, but their bachelor's degree, sorry, my question, one second. Oh, excuse me. So their graduate degree relates to the job he or she is applying for, but their bachelor's degree is completely unrelated to that job. Will it affect the student's ability to apply for a job for H-1B or to seek H-1B? So graduate degree related, bachelor's degree unrelated to the job they hope to work for H-1B.
As long as they have the bachelor's degree, or I'm sorry, the master's degree, the graduate level degree related to the position, you'll be just fine. It's whether the entry level position requires at least a bachelor's or higher. So if they have a qualifying master's or PhD, you would use that as the basis to prove your qualifications for the position.
Okay, thank you. I think we have time for about one more. I'm just trying to find one that we can answer. This last one is just, how does the H-1B lottery affect medical residents and prospective fellows? Are they exempt from these changes?
No, they're not exempt, but so many medical trainees are in J1, meaning they have to get a waiver. And if they get a waiver, they become exempt from the H-1B cap, because that's one of the benefits of the waiver. So, but again, that becomes kind of case specific. But most of your trainees medical trainees are going to be in J1 with the 2-year home residence obligation.
Okay. Well, thank you so much, Bob and Debra, and thank you, Tyler, for moderating the questions. So I just wanted to go to our final slides here. So I know that there were a lot of questions that were not answered today. Obviously, we have a lot of things to discuss. I wanted to share, therefore, all of the contact information for all of us in ISSS. We invite you to reach out to us and contact us with any questions. Of course, for employees who are working at CU Denver, CU Anschutz, please come to our office, or contact us first. And if we have a case that we need to send to Bob and Debra, we will send it directly to them and we'll get them involved in the process. Of course, if you have your own immigration case that you're concerned with, you are welcome to go to Bob and Debra as you need to. Or to any other immigration attorney that you'd like us to refer you to. So thank you again, everyone. And we have one more slide here for Bob and Debra's contact information. All right. Thank you all for joining us, and have a great day, and let us know if we can do anything to support you.
Thank you so much.
Yeah, thank you.
Thank you all.
Are we?
Yeah, we're just waiting for everybody to. Thank you, Tyler.
Yeah, thanks, Tyler. You did a great job.
You're welcome. No problem. Happy to. Thank you both.